We have a quorum, and this is the appointed time. I call the meeting to order. First of all, I'd like to invite the administration and the deputations to come in.
Hello. Hả?係啊，冇錯。
唔係，主席唔係梁美芬。
邊個做主席？
嚇？
係我嘛？
係咯係咯。搞錯。我呢個係咪仲裁條例啊？你講律師修改。哦，可能第二條。
歡迎。
開學啦。
Hello. Christopher, hi.
Please be seated. Before I ask deputations to speak, I need to declare that I deal with arbitration cases in the Hong Kong IAC, Hong Kong International Arbitration Centre. I will first ask the representative of the Hong Kong IAC to speak, to be followed by other deputations. Then I will give the floor to the administration before I ask members to ask questions. Maybe for now, I allow 5 minutes for the deputations to speak. Let's start with Mr. Christopher Toll. Good morning, everyone. Thank you for inviting me. I am here to speak on behalf of the Hong Kong IAC. In 1998, since the ordinance and the rules were endorsed, they've never changed. Do they need to be changed? We see that things have changed. Things have changed in the international arena. If we remain unchanged, then our competitiveness will drop. And that's something that I don't want to see. Another thing. Well, this is arbitration. Maybe some deputations might think, what about mediation? Arbitration's changing, and in the international arena, sometimes mediation is touched upon in arbitration. For some cases, mediation is needed instead of arbitration. So there should be an agreement between the parties to appoint an independent mediator. There are many different mediation bodies providing different services. We're here to talk about arbitration papers and related issues. This rule is very important. As you see that the rules remain unchanged since 1998. If the body charge nothing, in the provision of the service, and they have to be self-financing, is very difficult. You see, the fees charged are very reasonable in comparison with overseas jurisdictions. The Secretariat and the Centre have cited examples for members setting the grounds to support the increase in fees. I will supplement if necessary. I'm a director in the Centre. I also deal with arbitration cases, so I know whether our fees charge are competitive. Mr. Tsai, anything to add? No, not for the time being. Then I will ask Ms. Kim Rooney to speak on behalf of the Hong Kong Bar Association.
Sure. The Hong Kong Bar Association thanks the Subcommittee for the opportunity to make submissions to it on these rules. The Hong Kong Bar Association supports the repeal of the existing rules and the substitution by the new set of rules as proposed in the draft that we all have before us. I think it's LN 115 of 2013. I've seen that HKIAC has attempted to accommodate some concerns expressed as set out in its letter of 16 September 2013. I don't know if it's the right time, but we would support those changes too.
Okay. Thank you, Ms. Rooney.
Next, I invite Mr. Lam from the Law Society. Thank you, Chairman, and thank you, members. I will be precise. The Law Society and the Bar Association share the same stance in this regard, save and except one point. That is, in the discussion of the changes, we've had a lot of discussions, but we did not hear from the members any views in relation to the approach of the revised views, that they are unreasonable. We've not heard any such views in our discussions. Thank you, Mr. Lam. Next, I will ask the representative of the Council of Social Development to speak. I don't have anything to add. What about Mr. Chiu? Well, I have spoken with Mr. Toh in the waiting room. Well, what we're trying to do is to make the pie bigger. Currently, Hong Kong lawyers cannot go provide such service on the mainland in this regard. So can we promote Hong Kong to use Hong Kong as Hong Kong law as the basis in arbitration and mediation? So first we have to make the pie bigger. There are mediations and arbitration, but we propose that they should be separated. We've had informal discussions with the representatives outside the meeting room. Sometimes in an arbitration there may be mediation and settlement. How can you ensure that there is a fairness in information, even when there is a settlement? Maybe there is certain disclosure in the cause. So the arbitrator becomes a mediator, and then with such information, the mediator again turns back into an arbitrator. So we think that there should not be mediation within arbitration. In Section 6, perhaps I don't understand it fully. That is, a body has to be set up before arbitration is enabled under the law. Say, for example, I want to use Hong Kong's law as the model law. Well, how can it be protected in this way? Say in Singapore, there are a lot of favoring policies. How can we ensure that there will be? But that we can use Hong Kong law. Can we suggest to the government to give more resources so that arbitration in Hong Kong can play a role in the international arena? Well, at least we can get some cases, get some more cases. No, that's all for now. If necessary, you can supplement. Thank you for your view. And now I ask the representative of the DOJ. Thank you. The role of the DOJ in the mediation rules is one of liaison to provide assistance to the Hong Kong IAC in the drafting of the document. To make sure that the wordings and the styles are in accordance with existing rules in Hong Kong. We don't have an active participation. In the promotion of Hong Kong's arbitration service, it is very important. It's also the policy of Hong Kong, and we continue to support this. Mr. To is right in pointing that the relevant ordinance and rules should be updated to keep up with the times, so that Hong Kong's status as an international arbitration center can be enhanced. We strongly support the amendment. Mr. Chiu mentioned about mediation. DOJ has spent a lot of effort into it. We've set up a working group. I understand that Mr. To is a member of the working group. I believe the working group will consider all the valuable input put forward by Mr. Chiu. Since the rules is a subsidiary legislation under the principal legislation, so in relation to mediation related to arbitration, in Section 32 of the ordinance states that with an agreement of arbitration, the rules only applies in these circumstances in the appointment of mediator. This does not apply to appointment of mediators in other cases. I just want to clarify this. So this does not affect the appointment of other mediators. This is only related to the appointment of mediator in the process of arbitration. I just want to clarify this.
Thank you. Thank you. And we'll now invite members to ask questions. Mr. To, thank you. I'd like to thank the deputations for coming today to discuss with us this topic. Of course, I am a layman, I must declare, first of all, so I'd like you to take some time to explain some of the details so that we can have a better grasp of the whole issue. I've heard the deputations saying that they would like arbitration and mediation to be totally segregated. So, Chairman, I'd like to chairman this question, and the department and the deputations can also answer the question. In the case of Hong Kong, is it the case that the two processes of arbitration and mediation could be combined, and that's why you have this view? We've heard clearly from the industry or the trade that if a mediator subsequently becomes an arbitrator, it would affect his neutrality and impartiality. And the parties concerned may not think this is fair. However, I wouldn't call the arbitration and mediation are two different types of industries or professions. What I'd like to know is whether or not there is any communication or consensus between the two professions as to whether this is the direction that we should adopt. And if the two were to be entirely segregated, then for individuals or parties which would like to, resort to arbitration, how would it impact on their costs? If we go from a mediation process to arbitration, or halfway through an arbitration process, the parties want to go back to mediation. How does that happen? I mean, what suggestions do the deputations have to say? Ms. Ho, let me, if you don't mind, and if the chairman gives me the chance, I'd like to explain that the arbitration and mediation processes could be helped to resolve disputes, and both processes are adopted voluntarily. The DFJ already said that very often the parties will start with arbitration, and when the process reaches a stage when the parties think that there's a point which cannot they want to resolve it before the arbitrator comes up with a judgment, and therefore parties can voluntarily, go for mediation. So in that case, the arbitration becomes. So if the mediation is successful, then of course you can go back to the arbitration process. If not, there are many laws, many processes, and even our codes stipulate clearly that if the mediator has obtained certain information in the process of mediation, even if the mediation fails, such information will need to be disclosed totally. If that's not the case, if one party has access to such information, then it would damage the reputation of the arbitrator, and nobody will appoint you afterwards. And this is, well known in the industry worldwide. So our legal provisions and the rules are very clear on that. Sometimes people may opt for mediation halfway through arbitration process. This is because of commercial considerations. Sometimes they may not wait until the arbitration ruling has come, and they would like to resolve the dispute as soon as possible. So far, I've not seen many parties wanting to go from arbitration to mediation and then back to arbitration. And so already said that they may not think that this is really to the best interest, and that there might be an opportunity that the information may not be totally clear. But people are now seeing that this process is very flexible, and it can allow the business sector to discover that it can expedite the resolution of the dispute. Some people think that the arbitration sometimes takes too long, and mediation sometimes can help expedite the process. And if we do not have a flexible procedure, then Hong Kong's competitiveness as an arbitration center would be impaired. In China and Singapore, they are already adopting this system. If we don't, then our status as an hub for arbitration services may be adversely affected, and our standard may also drop. And this is not something we like to see. Thank you. Now I understand. I also like to know this, that is, if the parties to a dispute want to go from arbitration to mediation. Now, mediation is relatively new, in Hong Kong. So for both professions, is there, a mechanism for the two professions to communicate? One deputation said that the arbitrators and the mediators should be two separate groups of professionals, otherwise it might affect the neutrality of the arbitration process. Is there a good, communication between the two professions? That is, halfway through the arbitration, the parties want to resolve the dispute more expediently. I mean, is there a good dialogue between the two professions to help facilitate that? Well, the DFJ already said that while I'm sitting on that working group on mediation under the DFJ, I think not all members are mediators. I have a background in both arbitration and mediation. Raymond Leung is also an arbitrator and a mediator himself. We have communication between two professions, and this is important because the market is changing. If we only rely on arbitration without resorting to mediation, then our standard may fall. So as whether or not there is communication. In fact, many different parties like Ms. Rooney, her colleagues, have been involved in the works of different organizations. They also think that some people are suitable to become arbitrators, others are more suitable to become mediators. Of course, there are others yet who can be both due to their temperament and personality. Some people are inclined to become, some people like to become mediators, some people like to become arbitrators, some people can be both. For such people, I can say, I think there is communication almost every week because they communicate through WhatsApp, they consult my views on various matters. There's a lot of communication because we want to perfect the mechanism so that Hong Kong can become, when Hong Kong can tell the whole world that we are doing very well in this respect. Any further questions, Ms. O? Not for the time being. Chairman, regarding the decision on the number of arbitrators and that the number could be 3. What is the rationale between that suggestion? How does one decide on the number of arbitrators for a case? What are the qualifications required or experience required of such arbitrators? Very often in the contract it is stipulated that the two parties will select either 3 or 1 arbitrators. Where there are 3 arbitrators, parties to an arbitrators will look at the background of the person concerned, and then there are some arbitration cases which doesn't require someone arbitrated to have a legal background. Very often engineers and accountants could be appointed arbitrators. For the IAC to make that such an appointment, the reputation of the person is very important. If you appoint someone which is not qualified, then there might be complaints, and the IAC doesn't want such complaints. Very often they would require these persons to attend courses. It's not, the training is not offered by the HKIAC, but there are different organizations which provide training and certify that a person has required to achieve the competence standard. As to when the IAC will appoint an arbitrator, that is, if the two parties fail to agree, then the IAC will make that appointment, will appoint an arbitrator. Very often, for international arbitration, very often 3 arbitrators are appointed. This is because you may have a U.S. company, a Korean company, and the two parties don't trust the arbitrators from the other country, and very often they would like to select 3 arbitrators as a result, so that the American party will select an American arbitrator, the Koreans will select a Korean arbitrator, and then the 2 arbitrators will sit together to select a 3rd arbitrator, which normally would be from a 3rd country with a different background. If a 3rd arbitrator cannot pick a 3rd arbitrator, the ICC will come in. Well, the arbitrator may have different background. and the views of the three arbitrators may vary, and they may be, biased towards one party. Would that complicate things? I think the arbitration system provides the guarantee that if one party doesn't agree, then they will not sign the arbitration ruling. I think the arbitrator can explain why he would refuse to sign the verdict or the ruling. I think this has happened in Hong Kong and elsewhere. Mr. Tam, I also have a few questions myself. The deputations earlier query whether or not the Hong Kong SAR government is actually making enough efforts to develop the arbitration industry in Hong Kong. In August, I've written to the DFJ and Mr. Gregory So. In my letter, I pointed out that the government is not providing support to promote the arbitration center. If you look at Singapore, they really provide a lot of support for their arbitration center. And you can see that they have achieved some results. In 2012, compared with last year, the number of arbitration cases has gone up by 25%, and the amount involved number of cases, arbitration cases in Singapore every year involve an amount of $3 billion US. If Singapore can do it, why can't we do that? I like the Hong Kong government to see how it can help the HKIAC and other arbitration centers and to provide more support to help promote the arbitration services in Hong Kong. Because I don't think such support is sufficient at the moment. Chairman, we've already received the chairman's letter, and like the chairman himself, we are also concerned about the importance attached to the arbitration service in neighboring countries and the efforts that they have made. We are very clear that in order to maintain our competitiveness, we need to put in greater efforts to promote Hong Kong as an arbitration hub. I think the updating of the rules is part of that effort as to how we can work together with the arbitration profession to promote Hong Kong internationally. We'll certainly work hard along that direction. We are constantly in touch with the HKIAC and other organizations to see how we can further improve the arbitration services in Hong Kong. We have working groups and other, informal dialogues going on all the time, including our contact with the Law Society and the Bar Association. Very often we will sit together to see where we can do better. And we'll certainly reply to the chairman's letter as soon as possible. We'll explain to you what we are doing and what we will be doing going forward. I understand that the difficulties faced by the Hong Kong IAC is that not enough effort is made in terms of promotion. They are now applying to the government to for funding under the Professional Services Promotion Fund. But the process is very protracted, and the funding they get is not not enough, and they're relying on funding from this fund to do the promotion. So if the government could, cut the red tape and give them more resources to do promotion, then I think our competitiveness in the international market will increase. For example, I've gone to Seoul recently to attend the opening ceremony of the International Arbitration Center. Even though in South Korea, I think they're slightly behind Hong Kong, but they are putting in a lot of efforts, and they have a lot of determination like Singapore. They really like to promote the arbitration business, and I think Hong Kong is lagging behind. And that's why I want the government to really put in resources to promote Hong Kong's arbitration services. Otherwise, our status as an arbitration center in Asia will be weakened. So I hope you will give us a reply, both to myself and the IAC, as to how you will step up your efforts to help promote the arbitration services in Hong Kong. Mr. Chiu, how about the mainland? I have to ask the DFJ this question. We've actually signed an agreement earlier about arrangements in respect of arbitration rulings. Could other parties, conduct arbitration and mediation in the mainland based on Hong Kong laws? China is a huge market in respect of arbitration and mediation services. So could we update our system? I think internationally, the arbitration and mediation processes are improving all the time. China, which is the nearest market for Hong Kong, I wonder whether we can come up with something, or whether we can come up with some sort of agreement so that we can conduct such sort of arbitration or mediation.
Just now, Mr. Chiu mentioned about mediation, arbitration rulings. We'll continue to take forward with other places in the provision of mutual legal aid. And in relation to commercial contracts, if there is a ruling, they are recognized both in Hong Kong and the mainland. And this actually is a step forward. And in relation to the huge difference between the laws of Hong Kong and those on the mainland, we will keep the dialogue open to see how much we can do. Well, actually, we have an advantage here. In Japan, they have continental law, so is Germany. So if we are to do international mediation or arbitration, you need a pool of talents who know continental law and US-UK law. In Hong Kong, we are proficient in both systems. So would you do something along this line? I think you've heard it. Yes, I have. We have staged a lot of activities covering services provided in Hong Kong. And we promote the use of Hong Kong services on the mainland as well. But if on the mainland they want to use Hong Kong laws, well, there are restrictions because there is a different system on the mainland. Sorry, I have to interrupt you. We have an advantage when it comes to the two systems. So are there any promotions? There are different countries using different systems, but in Hong Kong we are proficient in both. And this is an advantage that is not seen elsewhere. Can we do something along this line? Well, perhaps we won't be able to have a recognition of both systems in both places, but can we have some promotional activities telling people that Hong Kong talents are proficient in both systems? Thank you. Mr. To would like to add. The DOJ has done a lot. They have done a lot in the front line. They work with the Trade Development Council in the promotion of Hong Kong's advantage on the mainland. The IAC has been listening to the views of people from the mainland and also stakeholders. But on the mainland, they may not know much about the basic law or the common law. We've given views to the DOJ about the possibility of setting up offices by mainland organizations in Hong Kong. Well, actually, there is an office set up recently in Hong Kong, and that office is in close liaison with Hong Kong. And you see that a lot of arbitration cases are dealt with in Hong Kong, engaging Hong Kong mediators, arbitrators, and lawyers. So the DOJ has done promotional activities. We're now working on how to appeal to them so that we can attract cases to come to Hong Kong. Well, Ms. Kim Rooney represents the ICC, and which has an office in Hong Kong. Overseas countries now recognize the advantage of Hong Kong. Say Germany and France, there are cases done in Hong Kong because they recognize our legal advantage. You can see that we are anxious for things to go more quickly. We're working on it, and we're working with the DOJ. Ms. Rooney?
Thank you very much, sir and madam, and thank you. May I mention on promotion of Hong Kong, I would speak about international, not mainland, if I may, but I would support the comments of Mr. Christopher Toh in terms of the efforts that the DOJ has given to support international arbitration in Hong Kong. As Mr. Toh has mentioned, one of my hats I wear is the chair of the ICC Hong Kong Arbitration Committee, but also the chair of the Bar Association International Relations Committee. In February this year, a group of us went to India to promote Hong Kong dispute resolution services, arbitration, mediation. Why did we go this year? Because in a big part, thanks to the lobbying of DOJ, but also others, the law in India was changed so that India now, as you know, now recognises Hong Kong arbitration awards as being part of a big family, the New York Convention family. And so that was a process that took a lot of work, but it happened. And so now it's only a start, but there's now no impediment for cases which have an Indian aspect to be dealt with in Hong Kong. And so similarly, we have done promotion in Singapore, and we are doing promotion. This is all kind of, for many of us, voluntary, ad hoc, although with support from DOJ or Trade Development Council, HKIAC. But I don't want to be long-winded. I just want to say that certainly we are trying to build on efforts that the DOJ and others have made to promote Hong Kong as an arbitration centre. And my impression is, as someone who mainly works as an arbitrator, but is also involved in ADR law reform in other countries, my impression is Hong Kong, the tide is coming back a bit to Hong Kong. People are recognising that our system of integrated dispute resolution, because most parties just want a solution. They don't care if it's I mean, I don't mean to be disrespectful, but they don't care if it's arbitration. They don't care if it's mediation that gets them a result. They just want a result. And so, if I may say so, I think one of the strengths of the Hong Kong system is this integrated approach we have, where we can offer arbitration, we can offer mediation, and I think that word is getting out, although we need to do more, of course.
Thank you, Ms. Rooney. Thank you.
Ms. Ho? South Korea spent a lot of effort in the promotion of their industries. In summer, I have visited them to look at their cultural initiatives and also the innovation and creative industry. But language is a huge barrier for them. They are really localized. So it's difficult for them to get international recognition. But if we want to be an international arbitration center, how much will the translation demand be? In our desktop research and information collection, well, in Hong Kong, we are all right with Chinese and English, but not a third language. Well, if we want to be the best in Asia, then can we also deal with Korean cases that are in Korean? Say, for example, Japan, the documents will be in Japanese. Has the administration done anything, whether to find out whether there is enough support in translation, and can the sector tell us about the support of a translation to and from different languages? Mr. Tai. There are difficulties encountered by all the countries. I know that recently there is a Mongolian case in Hong Kong. No one knows Mongolian, so we have to approach people in Mongolia to see if they can help. The Hong Kong the Law Association has got some people on the list with Korean background. You see that there are people from different countries coming to Hong Kong to practice law, so that is good. So, is it the case that Korea is better than us? I don't think so. I think it's the other way around. But there is always room for improvement. I know that different institutions, City U, Hong Kong U, they have translation courses. A lot of graduates set up their own companies to provide translation service that are of good quality. I'd like to say something in response to Ms. Ho about translation. On our register, we have arbitrators from over 39 countries. They speak their own mother tongue, and they are fluent in English. If you want to find an arbitrator that speaks Korean, well, it's very easy because we have a lot of them on our register. And if you want to engage a lawyer, overseas lawyers are allowed to attend in the tribunal. And we have a counsel, an in-house counsel who is a Korean. The counsel can deal with Korean cases, documents written in Korea. And we also have Spanish arbitrator and people from India as well. So in terms of language, Hong Kong has an advantage, and there are a lot of translation service companies in Hong Kong providing simultaneous interpretation service and translation service on major and some minor languages. Of course, Chinese and English pose no problems. And we have an advantage in this regard. And I'd like to respond to what Mr. Chiu said in relation to promotion on the mainland. We are aware that in Hong Kong arbitration cases, a lot of them involve mainlanders. We, on average, deal with 100 arbitration cases involving mainland parties. In 2009, we obtained funding from the government dedicated fund to stage promotional activities lasting for 2 years. It's proved to be very effective. We reckon that the number of cases involving mainland parties will increase. You have something to say? Thank you. Ms. Ho mentioned about translation support in Hong Kong and whether it's sufficient. Well, actually, there are two parts to this problem. One, language. The cases conducted in Hong Kong use English. most of the arbitrators and lawyers are proficient in English, and the other side involves the witnesses and the parties. They are from different countries, perhaps. In private sector, translation service provided by private companies all provide English translation service. When it comes to dispute resolution center of mainland cases, we offer high quality service. It's not just Putonghua, English, and Cantonese. Sometimes dialects, say for example Shanghainese, are involved, and we have sufficient service. Maybe the people are not native from Hong Kong, and whether we should groom our own talent, that's a different issue.
Would you like to respond at this point? If not, if other members have no further questions, why don't we now move on to the clause-by-clause scrutiny of the rule. I'd like to ask our legal advisor to first of all, make some comments. Over the course of the summer holiday, I have been in touch with the Arbitration Center, and I raised certain drafting points to them, and they accepted most of my suggestions. In respect of 6 of the provisions, I have proposed some amendments. For the convenience of members, I've actually prepared a marked-up copy for members' reference. I'd like to go to section 13. There are 3 parts in section 13. First of all, fees. The fees is set at $8,000, and then in subsection 2 it says that the fee could be more than $8,000 but not exceeding $15,000. The Arbitration Center has really explained their policy intent. They would like us to give them the power to review the fees from time to time, subject to a cap of $15,000, and that they don't need to come back to LegCo every time they varies the fees or adjust the fees from $8,000 upwards up to a ceiling of $15,000, and there is no need to announce the new fees in the Gazette. Section 3 stipulates that after they've adjusted the fees, they should put up a notice and also announce the new fees through the internet. I'd like members to suggest whether or not the IAC could resort to administrative means to adjust the fees rather than doing so by way of legislation. Well, I think the deputations may need to stay the IAC. If the other deputations would like to leave now, please feel free to do so. The legal advice, regarding the legal advisor's suggestion, perhaps Mr. To, you could respond. I've already said just now, Chairman, that from 1998, since 1998, the fee of $4,000 has not been changed. The IAC is a non-profit-making organization. If we have to pay for our own promotion and to help people arrange for arbitration services, it's not really viable. After we've done our calculations, and we've also shown the DFJ and LegCo the rationale as to why we need to raise it for $8,000. If you take the manpower costs and so on, I think the market rate should be $8,000. We want a ceiling of $15,000 because we want to stay competitive. We want to be expedient. If every time we adjust our fees, we have to come back to LegCo, we may have to wait for a long time, and as a result, our competitive edge may be impaired compared with Singapore and Korea. I think if we set the cap of $15,000, we envisage it would take some time yet before we come back for another revision. So we'd like members to agree that we be given the flexibility so that we can respond to the market as quickly as possible. And that's why we need that flexibility and this range that we are proposing. Mr. Tam, in many of the rules, whenever fees are involved, you would need to go through a procedure in this council. I've heard Mr. To's explanation just now, and if that's the case, you may need to go through some procedure before you can adjust your fees. If we could give you that flexibility for you to do so administratively, it would make things more expedient for you. But if we give you such powers, we hope that you would exercise such powers carefully instead of raising the fees abruptly. Otherwise, it may deter people from, wanting to go through arbitration in Hong Kong, because we might scare our customers away, so to speak. So, if we give the HKIAC such powers, I hope they would exercise such powers judiciously, in order that there will not be too much criticisms. Thank you, Mr. Tam. Ms. Ho, I don't want to set a precedent here, because whenever we talk about fees, we're not just talking about legal services. We have fees covering other livelihood issues. If we make a precedent here, and if other organizations and the government propose allowing such flexibility to other organizations, we don't know what would happen afterwards. I'd like to explain to the profession that very often you take the negative vetting approach. I mean, the delay is not due to LegCo. Once it is announced in Gazette, you can already, vary the fees. I'd like the DFJ to explain this. Before Gazetted, when the profession discussed with the government regarding the fee revision, how long does it take before the new fees are announced in the Gazette? So could the legal advisor and the department explain to us that starting from the time the industry, the profession want to change the fees to the time the new fees are gazetted, how long does that take? If you go through the negative vetting process, if the change adjustment is not very unreasonable, it can almost come into effect immediately. DFJ. Mr. To. Ms. Ho, there is another question here. If the fee is set at $8,000, very often the parties may need to liaise with our secretariat. Very often they will have to ask many questions before an arbitrator could be appointed. So the $8,000 is the minimum. If it takes 3 months, 6 months time before we can find the arbitrator, a lot of manpower may be involved. So for many of the cases, you'll find that the IAC is losing money if we charge $8,000. That's why we need that flexibility to set the ceiling at $15,000, which is the maximum. Very often, if the secretary of the IAC wants to increase the fees to $9,000, for example, before they do that, they will need to consult the 3 members of a working committee under the IAC as to whether that is reasonable. Otherwise, if the committee thinks that it's not reasonable, such an increase will not be allowed. So there are procedures in place within the ICAC to scrutinize any proposed increase in fees. So the council may also may have a power to decide whether or not such increase in fees are allowed. So it's not a complex procedure, but we have a system in place to ensure that there is transparency. You do exercise such a decision. You do make such a decision judiciously. I would prefer that. What would the arbitration center would like that flexibility? I would prefer that we stipulate in the legislation itself that there is such a range for you to decide on, rather than saying that if you need to adjust the fees, you don't want to come back to LegCo. I would prefer to give you that flexibility, in the first place. Any response from the DFJ in respect of Section 13 on the subject of fees? Chairman, I'd like the chairman and members to note that other than the range of $8,000 to $15,000 as stipulated in subsection A, one must realize that we have to satisfy requirement B or 2B. That is, the HKIAC can only charge a reasonable fee to pay for the expenses incurred. So that is one condition. The HKIAC would need, when they need to raise the fees, they have to bear this in mind, and it will not, jeopardize the objective stipulated in subsection 3. That is, namely, would not result in any unnecessary, expenditure. So these are the constraints, or considerations which the IAC will need to make before they adjust the fees. I also like to supplement that HKIAC has its own council, and the council members are representatives of the professions, and they are the users of the arbitration services. If the HKIAC suggests that the fees be increased, then members of its council, who are the relevant stakeholders, can also express their views. So I think there is some protection there already. Thank you. Chairman, under Section 13, if one looks at Section 13, does it mean that the power is already given to the IC that it may charge a fee ranging from $8,000 to $15,000, so long as it is within that range? They already have the power to do that, so long as the fees are reasonable. That's my understanding too. Yes. Basically, this allows the HKIAC the flexibility. Right now, it's set at $8,000, but in future it could be raised to $15,000. But within this range, if the IAC wishes to increase the fees, then it doesn't need to come back to LegCo. So, are you saying that $15,000 is not enough? No. What they're saying is that in the foreseeable future, they might need to raise the fees up to $15,000, depending on the circumstances. If they need to balance, make up for the costs incurred, then they would need to raise fees, but it would not go beyond $15,000. So, but they don't need to come back to LegCo if they were to raise the fees up to $15,000. Yes, that's my understanding. Unless the IAC feels that very soon they have to raise the fees beyond $15,000. In that case, they'll need to come back to LegCo. Oh, I'm sorry that the fees, if you think $15,000 may have to be exceeded in the foreseeable future, I would prefer that you change that ceiling now, rather than giving up our legislative powers and leave it to the IAC to change the fees through administrative means. Ms. O, are you saying that do you agree that $15,000 is reasonable? If the profession believes that $15,000 may not be enough, and very soon the threshold may need to be raised, and to go through, if they need to do that, they have to go through a protracted legislative procedure. I would prefer they stipulate clearly here that the power be given to LegCo, so that we can discuss, say, if $15,000 is not enough, how much should the ceiling be raised? Just because you need to respond to the market quickly, we don't want to convert our legislative power and turn it into an administrative power to be exercised by the IAC. Well, I think Ms. Ho's concern is that if very soon you think that $15,000 is not sufficient, say a year from now you've increased the fees up to $15,000, and even that is not enough, and you have to come back to LegCo. to apply for that ceiling to be raised to say 20,000, then you have to come back to LegCo to amend the rules. And Ms. Ho is concerned that when you come back at such time to apply for the amendment or for the changing of that ceiling, and you have to go through a legislative process, and you respect that process. You understand that? So in the foreseeable future, and you're now raising it from 4,000 to 8,000, and in the foreseeable future, you may need to raise it up to 15,000. But if you need to go beyond 15,000, you have to come back to this council. You understand this? Yes. Does that answer your question, Ms. Ho?
I see in some submissions that they would like to leave it in the hands of the Hong Kong IAC when it comes to the revision of fees. But I would like to see the LegCo playing a role. If the sector thinks that they will reach the 15,000 ceiling in no time, I think the legislative procedure will have to be respected. If the industry thinks that 15,000 is too low, it will be exceeded in no time. I'd rather we have a discussion here today about the appropriate level of the ceiling, and if in the future the ceiling is reached and they have to be raised, and then I would like them to come back to the LegCo. I think the point is that they don't see in the near future it will go above 15,000, so there is no such possibility. Ms. Ho's view is that if it does exceed 15,000, they have to come back, and the deputations realize that. That is my understanding. Mr. To, you understand that? Yes? Yes. We understand that if it exceeds 15,000, then we have to come back to the LegCo. Well, there was a change from 4,000 to 8,000. It will be a long time before it goes above 15,000. And we would like to break even, but still we need to provide a service, a reasonable and affordable service. Well, that is clause 13. On this, any other views? What about 4, 6, 8, 10, and 13 and 15? Perhaps we will deal with them together. Does any other members have any views on other clauses or any questions? No? Legal advisor. 2 things to add. 13. Well, you see the red in the markup copy are those proposed by the Hong Kong IAC, which I agree. For 13B, which is a yellow, that is a consequential amendment. I've had a discussion with the DOJ and the Hong Kong IAC. If they don't have a different view, they will be adopted. The Hong Kong Institute of Engineers on the 5th of September sent us a letter. They expressed the views on they proposed some amendments on the wordings. The Hong Kong IAC has not responded. Perhaps they should do so now. This is paper number CB bracket 4976/12 to 13 bracket 03. The Hong Kong Institute of Engineers. The letter dated the 5th of September. Well, I'm also a member of the Hong Kong Institute of Engineers, and I participated in the various subgroups. They would like to standardize the wording. We've discussed with the DOJ there will be a handbook, and it will be listed out very clearly at the back of the handbook what the terms refer to. We've drawn reference from the international documents. It's not just how we want it to be written. we would like overseas cases to know what these terms are referring to, because they are used in overseas documents. The Institute of Engineers would like to clarify every single term, but this may cause confusion when overseas parties come to Hong Kong. After discussion with the DOJ, we think that we can come up with a handbook to provide a supplement so that users will know what these words and terms refer to. Ms. Rooney?
Present wording, do you have any comments? Or,
No, I do agree, and I don't have any comments.
Okay, thank you.
A procedural matter. In relation to the 6 clauses to be revised, will the DOJ assist the Hong Kong IAC to move amendments so that the S4J will move these amendments in the Council? Thank you. In relation to the procedural issue mentioned by the legal advisor, the S4J will move an amendment in the Council meeting. I think we would adopt the usual procedure in a sub-leg. So, any other members who would like to say anything in relation to all these issues? If not, I believe, well, when do we have to get back to the House Committee? Without an extension of a scrutiny period, we have to report to the House Committee on the 4th of October. I don't think we need an extension. We will report to the House Committee as soon as possible. Any other questions or issues? Do you think you will be able to make it before 16th? I will discuss it with the secretary, with the clerk. You have to give us an answer now. Can you? Not at this moment. Well, then liaise with us, and I will liaise with the clerk. Well, there being no other business, meeting adjourned. Thank you.
如果佢做唔到，可能就要 extend。